Unit 1. Indian Constitution. Learning Objectives. To know about the making of Indian Constitution. To know the salient features of Indian Constitution. To understand the fundamental rights and duties. To know the directive principles of state policy. To understand the center-state relations and the emergency provisions. Introduction. The Constitution is the fundamental law of a country which reflects the fundamental principles on which the government of that country is based. It is the vehicle of a nation's progress. The concept of constitution was first originated in USA. 1.1. The need for a constitution. All democratic countries have a constitution that governs them. A constitution puts down certain principles that form the basis of any kind of a state that we as citizens desire to live in. A constitution tells us the fundamental nature of our society. 1.2. Making of Indian Constitution. The Constitution of India was framed by a Constituent Assembly set up under the Cabinet Mission Plan 1946. The Assembly consisted of 389 members representing provinces, 292, states, 93, the Chief Commissioners Provinces, 3, and Baluchistan, 1. The Assembly held its first meeting on 9 December 1946. Dr. Sachidananda Sinha, the oldest member, was elected as the temporary President of the Assembly. While the work was in progress, Dr. Sachidananda Sinha died. Dr. Rajendra Prasad was elected as the President of the Assembly. Similarly, both H.C. Mukherjee and V.T. Krishnamachari were elected as the Vice Presidents of the Assembly. The Assembly met for 11 sessions along with 166 days of meetings. During the discussion, 2,473 amendments were presented. Some of them were accepted. The Assembly worked through various committees and the draft of the Constitution was prepared by the Drafting Committee under the chairmanship of Dr. B.R. Ambedkar. He is recognized as the father of the Constitution of India. After the draft had been discussed by the people, the press, provincial assemblies and others, the Constitution was finally adopted on 26 November 1949, contained a preamble, 22 parts, 395 articles and 8 schedules. The drafted constitution came into force on 26 January 1950. This day is known as the Republic Day. It is being observed every year. Highlighted section. Do you know? Prem Bihari Narayan Raijada was the calligrapher of the Indian Constitution. The original constitution was handwritten by him in a flowing italic style. Regular section. 1.3. Salient features of Indian Constitution. It is the lengthiest of all the written constitutions of the world. It has borrowed most of its provisions from the constitutions of various countries. It is partly rigid and partly flexible. It establishes a federal system of government. It makes India as a secular state. It provides an independent judiciary. It introduces universal adult franchise and accords the right to vote to all citizens above 18 years of age without any discrimination. 1.4. Preamble. The term preamble refers to the introduction or preface to the Constitution. It consists of the ideals, objectives and basic principles of the Constitution. It has great value and has been described as the key to the Constitution. The preamble to the Indian Constitution is based on the Objective Resolution drafted by Jawaharlal Nehru, which was adopted by the Constituent Assembly on 22 January 1947. It has been amended once by the 42nd Constitutional Amendment Act of 1976, which added 3 new words: socialist, secular and integrity. The preamble begins with the phrase, "We, the people of India." Thus, we can say that the people of India are the source of our Constitution. The preamble of our Constitution states that India is a sovereign socialist, secular democratic republic. Its aim is to secure to all Indian citizens social, economic and political justice. Do you know? Liberty, equality and fraternity were the important slogans during the French Revolution in 1789. They are given importance in the preamble of our Constitution. Regular section. 1.5. Citizenship. The word citizen is derived from the Latin term civis. It means resident of a city-state. The Constitution of India provides for a single and uniform citizenship for the whole of India. Articles 5 to 11 under Part 2 of the Constitution deals with the Citizenship. Citizenship Act, 1955. The Citizenship Act of 1955 provides for acquisition and loss of citizenship after the commencement of the Constitution. This Act has been amended so far 8 times. Acquisition of citizenship. According to the Citizenship Act, 1955, the citizenship could be acquired through any of the following methods. 1. By birth. All persons born in India on or after 26 January 1950 are treated as citizens by birth. 2. By descent. A person born outside India on or after 26 January 1950 shall be a citizen of India by descent, if his father is a citizen of India at the time of his birth. 3. By registration. A person can acquire citizenship of India by registration with appropriate authority. 4. By naturalization. A foreigners can acquire Indian citizenship on application for naturalization to the Government of India. 5. By incorporation of territory. In the event of a certain territory being added to the territory of India, the Government of India shall specify the persons of that territory who shall be citizen of India. Loss of citizenship. The Citizenship Act of 1955 prescribes 3 ways of losing citizenship, whether acquired under the Act or prior to it under the Constitution, viz. Renunciation, termination and deprivation. 1. It can be voluntarily renounced by a citizen. 2. It can be terminated if a person acquires the citizenship of some other country. 3. The central government can deprive a naturalized citizen if it's satisfied that the citizenship was acquired by fraud, false representation or concealment of material facts, or indulges in trade with enemy countries, or if the person has been sentenced to imprisonment for a period of 2 years. 1.6. Fundamental rights. The fundamental rights are enshrined in Part 3 of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA. Originally, the Constitution provided for 7 fundamental rights. At present, there are only 6 fundamental rights. Part 3 of the Constitution is rightly described as the Magna Carta of India. While fundamental rights are available to all persons, certain fundamental rights are available only to Indian citizens. Right to constitutional remedies, Article 32. A writ is an order or command issued by a court in writing under its seal. It is in the nature of a command or prohibition from performing certain acts that are specified in the orders of the court. Both the Supreme Court and the High Courts are empowered to issue 5 kinds of writs. That is why the Supreme Court is called the guardian of the Constitution. According to Dr. Ambedkar, Article 32 is the heart and soul of the Constitution. A. Habeas corpus safeguards people from illegal arrests. B. Mandamus. It protects the petitioner who requires legal help to get his work done by respective public authorities. C. Prohibition. It prohibits a subordinate court from acting beyond its jurisdiction. D. Certiorari. It quashes an order issued by a subordinate court by overstepping its jurisdiction. E. Quo warranto. It prevents usurpation of public office through illegal manner. Suspension of fundamental rights. When the President makes a proclamation of emergency under Article 352, the freedoms guaranteed under Article 19 are automatically suspended. The President can suspend other fundamental rights through specific orders. These orders must be approved by the Parliament. Differences between fundamental rights and directive principles of state policy. Fundamental rights. Directive principles of state policy. It was derived from the Constitution of the USA. It was drawn on the model of the Constitution of Ireland. Even the government cannot take away or abridge these rights. These are mere instructions to the government. These are enforceable by a court of law. These are not enforceable in any court. These have legal sanctions. These have moral and political sanctions. These rights strengthen political democracy in the country. The implementation of these principles ensures social and economic democracy. 1. Right to equality. Article 14, Equality before law. Article 15, Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Article 16, Equality of opportunity in matters of public employment. Article 17, Abolition of untouchability. Article 18, Abolition of titles except military and academic. 2. Right to freedom. Article 19, Freedom of speech and expression, assembly, association, movement, residence and profession. Article 20, Protection in respect of conviction for offences. Article 21, Protection of life and personal liberty. Article 21A, Right to elementary education. Article 22, Protection against arrest and detention in certain cases. 3. Right against exploitation. Article 23, Prohibition of traffic in human beings and forced labor. Article 24, Prohibition of employment of children in factories, etc. 4. Right to religion. Article 25, Freedom of conscience and free profession, practice and propagation of religion. Article 26, Freedom to manage religious affairs. Article 27, Freedom from payment of taxes for promotion of any religion. Article 28, Freedom from attending religious instruction or worship in certain educational institutions. Cultural and educational rights. Article 29, Protection of language, script and culture of minorities. Article 30, Right of minorities to establish and administer educational institutions. 6. Right to constitutional remedies. Article 32, it allows individuals to seek redressal for the violation of their fundamental rights. Do you know? Right to property, Article 31, was deleted from the list of fundamental rights by the 44th Amendment Act, 1978. It is made a legal right under Article 300 in Part II of the Constitution. Regular Section 1.7. Directive Principles of State Policy. The Directive Principles of State Policy are enumerated in Part 4 of the Constitution from Articles 36 to 51. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into three broad categories, viz., socialistic, Gandhian and liberal intellectual. These principles are not enforceable by the courts, but they are fundamental for the governance of the country. They aim at promoting the social welfare of the people. Dr. B.R. Ambedkar described these principles as novel features of the Indian Constitution. Highlighted section. The 86th Amendment Act of 2000 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. The amended directive requires the state to provide early childhood care and education for all children until they complete the age of 6 years. 1.8. Fundamental duties. The fundamental duties in the Indian Constitution are inspired by the Constitution of former USSR. In 1976, the Congress Party set up the Sardar Swaran Singh Committee to make recommendations on fundamental duties. The 42nd Amendment Act of 1976 added some responsibilities of citizens to our Constitution called the Fundamental Duties. This amendment added a new part, namely Part 4A to the Constitution. This new part consists of only one article, that is Article 51, which, for the first time, specified a code of 10 fundamental duties of the citizens. List of fundamental duties. A. To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. B. To cherish and follow the noble ideals which inspired the national struggle for freedom. C. To uphold and protect the sovereignty, unity and integrity of India. D. To defend the country and render national service when called upon to do so. E. To promote harmony and the spirit of common brotherhood among all the people of India, transcending religious, linguistic and regional or sectional diversities. To renounce practices derogatory to the dignity of women. F. To value and preserve the rich heritage of our composite culture. G. To protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for living creatures. H. To develop scientific temper, humanism and the spirit of inquiry and reform. I. To safeguard public property and to abjure violence. J. To strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. K. To provide opportunities for education to his child or ward between the age of 6 and 14 years. The 86th Constitutional Amendment Act, 2002 has also introduced the 11th fundamental duty under 51A, K, under which all citizens of India or parents shall provide opportunities for education to their children between age of 6 and 14 years. 1.9. Center-state relations. Legislative relations. The Union Parliament has the power to legislate for the whole or any part of the territory of India, which includes not only the states but also the Union territories or any other area for the time being included in the territory of India. The 7th schedule of the Constitution embodies 3 lists, namely, the Union List, State List and Concurrent List consisting of 97, 66 and 47 items respectively. The Parliament enjoys the exclusive power to legislate on subjects enumerated in the Union List. The State Legislature has exclusive right to legislate on the State List. Both Parliament and state legislatures have power to legislate on subjects contained in the concurrent list. But in case of conflict between the law of the state and the Union on a subject in the concurrent list, the law of Parliament prevails. Do you know? The Union List, State List and Concurrent List consisting at present 100, 61 and 52 items respectively. The 42nd Amendment Act of 1976 transferred 5 subjects to concurrent list from state list, that is, education, forests, weights and measures, protection of wild animals and birds, and administration of justice, constitution and organization of all courts except the Supreme Court and the High Courts. Regular section. Administrative relations. The administrative power of a state extends only to its own territory, and with respect to which it has legislative competence, whereas the Union has exclusive executive power over a. the matters with respect to which Parliament has exclusive power to make laws, and b. the exercise of its powers conferred by any treaty or agreement. Financial relations. Article 268 to 293 in Part 12 deal with the financial relations between centre and the states. The centre and states are empowered by the Constitution to impose various kinds of taxes. And certain taxes are imposed and collected by the centre and divided between centre and states based on the recommendation of the Finance Commission appointed by the President under Article 280 of the Constitution. Late Prime Minister Indira Gandhi appointed the Sarkaria Commission in 1983 to make an inquiry into the centre-state relations. The central government has implemented 180 out of 247 recommendations of the Commission. The most important is the establishment of the Interstate Council in 1990. Do you know? In 1969, the Tamilnadu government appointed a 3-member committee under the chairmanship of Dr. P.V. Rajmannar to examine the entire question of centre-state relations. Regular section. 1.10. Official language. Part 17 of the Constitution deals with the official language in Articles 343 to 351. Initially, the Constitution recognized 14 regional languages which were included in the 8th schedule. At present, 22 languages are recognized. Do you know? In 2004, the Government of India decided to create new category of languages called as classical languages. So far, the 6 languages are granted the classical language status, namely Tamil, 2004, Sanskrit, 2005, Telugu, 2008, Kannada, 2008, Malayalam, 2013, and Oriya, 2014. Regular section. 1.11. Emergency provisions. National emergency, Article 352. The President under Article 352 can declare emergency if he is satisfied that India's security is threatened due to war, external aggression, or armed rebellion, or if there is an imminent danger or threat. When a national emergency is declared on the ground of war or external aggression, it is known as external emergency. On the other hand, when it is declared on the ground of armed rebellion, it is known as internal emergency. This type of emergency has been declared 3 times so far in 1962, 1971 and 1975. State emergency, Article 356. Under Article 356, the President can declare an emergency in a state if the Governor reports that a situation has arisen under which the government of a state cannot be carried on in accordance with the provisions of the Constitution. The continuance of such an emergency beyond 1 year is possible only if emergency under Article 352 are in operation or the Election Commission certifies that there are difficulties in holding assembly elections. Maximum duration of the emergency can be 3 years. The state is governed by the Governor on behalf of the President. For the first time, the President's rule was imposed in Punjab in 1951. Financial emergency, Article 360. Article 360 authorizes the President to declare financial emergency if he is satisfied that the financial stability or credit of India or of any of its parts is in danger. In this type of emergency, salaries and allowances of any class of persons serving state or union, including judges of the Supreme Court and High Court, can be reduced by an order of the President. This type of emergency has not been declared in India so far. 1.12. Amendment of the Constitution. The term amendment denotes change, improvement and modification. Article 368 of the Constitution in Part 20 deals with the powers of Parliament to amend the Constitution and its procedure. Procedure of amendment. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose in either House of Parliament, and when the bill is passed in each House by majority of the total membership of that House and by majority of not less than 2/3 of the members of that House present and voting, it shall be presented to the President, who shall give his assent to the bill, and thereupon the Constitution shall stand amended in accordance with the terms of the bill. The Constitution amendment can be brought about only by the Parliament. State legislatures cannot initiate for any amendment to the Constitution. Types of amendments. Article 368 provides for 3 ways of amendments. 1. Amendment by simple majority of the Parliament. 2. Amendment by special majority of the Parliament. 3. Amendment by special majority of the Parliament and the ratification of half of the state legislatures. Highlighted section. Do you know? 42nd Amendment of the Constitution is known as the Mini-Constitution. Regular section. 1.13. Constitutional Reform Commissions. The National Commission to review the working of the Constitution was set up by a resolution of the Government of India in 2000 headed by M.N. Venkatachalaya. In April 2007, a 3-member commission headed by the former Chief Justice of India M.M. Punchi was set up by the then government to take a fresh look at relative roles and responsibilities of various levels of government and their interrelations. Summary. The Constitution of India was framed by a Constituent Assembly set up under the Cabinet Mission Plan 1946. The preamble of our Constitution states that India is a sovereign socialist, secular democratic republic. The word citizen is derived from the Latin term civis. It means resident of a city-state. According to Dr. Ambedkar, Article 32 is the heart and soul of the whole Constitution. In 2004, the Government of India decided to create new category of languages called as classical languages.